Oh, hello guys. How are you? You okay?
Very well,
Hiya.
very well, thank you.
Good,
Good.
thank you.
Good. So who have we got here? We've got David Votter, as we know. Yeah. And we've got Gabrielle and Louise from BTMK Solicitors. So if one of you want to introduce yourselves and what you do.
Sure. So I'm Gabby. I am a solicitor in our litigation department at BTMK. I am fairly newly qualified at the start of this year. And we deal with all sorts of litigation really, both commercial and personal, kind of a mixed bag. My particular expertise is in intellectual property law, but as I'm sure Louise will tell you, we deal with a lot of landlord and tenant work as well. So yeah, Louise, if you'd like to introduce yourself a little bit as well.
Hi, so yeah, my name is Louise, solicitor at BTMK, work alongside with Gabby. We do a lot of general litigation across the board really, and we do a lot of landlord and tenant work, both residential and commercial, but yeah, we do a lot of the residential side of things in terms of seeking possession for landlords.
Oh, okay. So that kind of forms the bulk of your work, I'm guessing?
Yes, it's a lot of our, we do it on a fixed fee possession basis, so it's a lot of our bread and butter, so it does bring in a lot of work for us, especially landlords not looking to necessarily spend a lot of legal fees, especially if there's rent arrears and things like that. So yeah, we do a lot of the landlord and tenant possession work.
I suppose that is it's a bit of a specialism, and you have to be able to speak to people in a certain way, because a lot of landlords, as we know, David, aren't very familiar with the process.
Yeah.
I think we found the release actually from lockdown quite busy. You're finding that, aren't you, David? But are you finding there's any I don't know, negative feedback? Are you finding any of your landlords are struggling to work with their tenants and on rents, and have you got any that have served notice?
Yeah, there's a few negative situations. There's some very genuine and some not so genuine. I mean, we've had one tenant before lockdown started. We had to serve a Section 21 on the 5th of May because they were just not paying any rent, and there had been a problem before lockdown. That's now escalated. They then said we served the Section 21 incorrect. It was meant to be 3 months. However, we served it before lockdown, so it was still 2 months. The landlord has instructed me to start the accelerated possession proceeding process. Now, as both the girls below will know, that's not going to be quick. So I've just managed that expectation with the landlord. Said, look, we can start that process, but you're looking at months before you'll probably get heard in court, and there's going to be a huge backlog. And I think the government, as always, have had their best intention in mind to, prolong the Section 21 to help tenants, but in their helping tenants, they end up not doing other people favours as well. So in doing that, they're creating a huge backlog of work that's going to go on. I don't know how they're going to cope with it. I've already done one online hearing with a separate client on a consultancy basis, and it's very disjointed. I mean, I don't know if the girls below have done one of the online hearings yet, but it's very much like the judges talk.
I didn't realise they were doing that. I mean,
they are, yeah. Yeah, they are.
And the amended one, is it good?
It was very, because I'm in the room, and obviously I'm not a legal expert. I can just give my letting head experience and the legal knowledge that I know. So I'm advising the client, and I'm trying to want to jump in and say stuff, but you can't. And then it's very disjointed where the judge is saying something, and because the internet connection's gone a bit, it's gone a little bit like, and then you're talking over each other. So it's very disjointed, and they ended up postponing it to a later date. So they're making that one, instead of nailing it there and then, they're like, well, we want to bring the whole case together because there's so many different bits, and do it in August. So that's just another prolonged case, which is going to add to a list of cases that the courts are going to be struggling with.
Do you Gabrielle and Louise, do you think that's a thing that actually could change? They'll do. I know we were discussing before about block hearings. Do you think that's something that will just be done online, and you'll have to sit in your chair there and do that? Out of curiosity.
Now, historically, they did used to do them block listing in person, and obviously they've now had to move them online and virtually. There might be some difficulties in actually putting that in practice, because there's got to be a balance of the parties, and obviously a lot of the tenants aren't necessarily legally represented. So you might find that some hearings can't go ahead because the tenants might not have the setup in order to attend a virtual hearing, or they just don't have the facilities and able to represent themselves online, because at court you sometimes would have the duty solicitor there by way of the CAB, so they won't necessarily have that virtually, so it might be that the hearing just can't go ahead because of that reason, and it just would get pushed back.
Interesting. I didn't think, yeah, it's access to technology and also the access to representation. I didn't think about that. But yeah, it's interesting, Dave, you had that experience. I didn't even know. Well, I did know. I just didn't realise. Yeah, and so you've run through that process. The only experience I can draw upon is that we've had a few serving notices, but we're having to do it as a formal procedure, working with tenants on their rent repayment plans. But this is where tenants have gone back home, and generally are students who can't go back to university and are basically obviously being held accountable for their rent, but also they're trying to work with it. So it's a very tricky situation, and it's, from our side, it's just managing expectations and risk, really, isn't it, David?
Absolutely.
Yeah. So you've touched upon Section 21s now. So how have you guys reacted to landlord serving notice and requesting proceedings?
It's a case of each landlord's circumstances. It may well be that they've got a property that they're looking to sell, and that still that's their motivation for gaining possession. So really, it does just boil down to each individual set of circumstances that landlord finds themselves in terms of what is motivating them to get back possession. I've had a couple of landlords that are owed rent arrears and were owed rent arrears prior to COVID, and have decided not to necessarily take action now, in terms of issuing proceedings and having them immediately stayed, so that they're at least in the court system as to when the stay does lift. But yeah, there's some.
Clarify, the stay is the courts temporarily being shut. It's a temporary suspension, isn't it?
Yeah, so there's effectively just a complete moratorium on possession. So what initially, pre-COVID, there were some noises about the possession proceeding. You couldn't even issue proceedings at all during lockdown, but further guidance was then given that proceedings can be issued. They're just not going to happen. Now, nothing's going to happen. So the court aren't serving the proceedings on the tenants, they're just effectively being stamped by the court and being issued, and that's it until the stay does lift.
Interesting. That's quite useful information, actually, David, for landlords in general. So yeah, because no one would know that. No one would know.
No, just get it in there. I think there's, it's just get in the queue, basically, isn't it? Is what you're saying, Louise? Is just get in the queue, because we all know when you serve a Section 21, you've got 6 months in which to act upon that. Otherwise, it then expires, haven't you? So if you can get your accelerated possession paperwork into the courts within that 6 month period, preferably as soon as that 2 months elapses, just get on it straight away, and then you're in the queue, and then it's just chipping away at that queue, I guess, isn't it?
Yeah. I'm doing a mix of online and physical. I mean, and also they're shutting a lot of the county courts. I know that the last county court where I used to I did a bit of clerking work way back when I was like a teenager, and I used to go to that court, and just seeing it shut like a couple of months ago, I was like, I didn't even realise.
Sad, isn't it?
Yeah, and also it's not helping with the backlog. Are you guys, Gabrielle and Louise, seeing a mixture of Section 21 and Section 8, or a mix of both? That's something David and I, when we were chatting.
Yeah, I mean, it's been kind of a mixed bag, really, and it depends on the individual circumstances. So if there are rent arrears, and we're more often than not, unfortunately, in the circumstances seeing that there are often rent arrears, then there is the potential to consider service of both notices, essentially. One thing that the Coronavirus Act did do was to extend the notice period for both Section 21 and Section 8 notices. So ordinarily, Section 8 would expire in 2 weeks, whereas now it will expire in 3 months, as will a Section 21. So what we often advise upon, if there are rent arrears, to our landlords, is perhaps consider service of both a Section 8 and Section 21 as essentially a belt and braces approach. As you know, there are a lot of procedural kind of hurdles for the Section 21 procedure.
Yeah.
It's not quite as stringent with the Section 8, although the Section 8 does in itself have some risks, as it's a fault-based procedure based upon the rent arrears normally. So this kind of scenario has perhaps offered kind of a safety net for service of both notices, as there's now really no procedural difference in terms of the actual notice expiring, as both periods are the same now. So if anything, perhaps it gives an extra bit of cushioning for landlords in those circumstances.
Just quickly on that, sorry Danny, just quickly on that, Gabrielle, where it's fresh in my mind. So say for example you did the Section 8 and the Section 21, if they then obviously paid off the arrears on the Section 8 so they're no longer 2 months and you relied on your Section 21, would there be a way you could still go for money judgment, or is it just be straight possession and then advise the client to reapply to courts for money judgment at a later date?
Yeah, I mean, it essentially depends upon what procedure you've gone through. Obviously, if you've issued proceedings already on both Section 8 and Section 21, you would have had to have issued standard possession proceedings. And if there are still rent arrears, you can still seek judgment for those rent arrears.
Okay.
But you would, in order to obtain an order for possession, if those 2 months arrears had kind of fallen away, the mandatory ground itself would have fallen away. You'd have to rely on discretionary. And we often see judges not liking to grant possession orders on those grounds. So yes, to answer your question, you can still seek judgment, providing you've issued standard possession proceedings on the basis of both of those notices.
Good advice, thank you.
Useful question. So how are the situation with the courts? I know we've touched upon it since they've been stayed. Is there any dates of reopening or any light at the end of the tunnel?
So initially there was the 3 month stay, which commenced at the end of March, and it was due to obviously expire at the end of June, but that has been pushed back by a further 2 months. So the long stop date at the moment that we're working towards is the 23rd of August. But the legislation under the Coronavirus Act did actually allow for a maximum of 6 months. So it may well be that come the end of August there might be another pushing back of that deadline, depending on what the situation may well be then. I suspect we're not going to know until nearer the time, because obviously we weren't aware until the beginning of this month that they were intending to push it back to the end of August. So unfortunately we're not probably going to have much sort of more news as to whether that date is going to get pushed back or not until that time. And it just means, as I said, it means that landlords can still serve notices during this period, so things can still sort of move on. It's not come to a complete standstill, and also the fact that, as I mentioned, proceedings can still be issued, albeit they're just nothing's happening with them. So it's a case of, if landlords are still keen to get back possession, it's just a case of issuing them and hope you're going to be more towards the top of the pile than the bottom of the pile. If you wait until, for example, the end of August, it's much better if you're sort of gung-ho about getting back possession, get your proceedings in and hope that they're going to be dealt with sooner rather than later.
They're like a Rambo approach. Yeah. I mean, we're seeing landlords, David, aren't we, that are quite motivated, despite the fact of, you know, tenants describing their scenario, or us trying to do the empathetic thing to be like, consider all options and consider their situation. But sometimes it is significant arrears that build up. I mean, how have you dealt with that in terms of your landlords, David, down in Kent?
That's not my dog, by the way. I don't know what that is.
Yeah, apologies.
Sorry, what was your question? No, I'm joking. It was about how they're dealing with the arrears, did you say? Sorry, I missed that last bit.
How are they doing? You know, we've talked about the nicey approach, but are some actually being very harsh and going...
You know what? A lot of landlords have been very... I mean, I've had I've had about 4 or 5 landlords that say, do you know what, because my tenant's been good, I would happily drop the rent to half to help them out. You know, if they've got any troubles, I want to know. I think the main thing, Danny, is people just want to know what's going on.
Yeah.
I mean, a lot of landlords we've spoken about before are heavily leveraged and mortgaged. So for that rent to not come in and them not to have rent guarantee and legal cover, which in essence, a lot of policies aren't paying out anyway,
Which we
they're out of
discussed in the previous video, didn't we, about legal cover? Yeah.
Well, and that's the trouble. And there's very limited policies that are still out there, still in fruition. So landlords will want to help, but on the same token, they don't have a bottomless pit of money, you know, especially ones that are mortgaged. So you've got Section 24 of the Finance Act 1995. You've got, you know, the fact that higher deposits cannot be relayed upon. You know, you've got several other factors, which means that landlords are getting taxed that they don't have the money that they used to have. You know, gone are the days where, oh, you know, unless they own the property outright. But then I've got a couple of landlords that own their properties outright. They're retired, they've got small pensions, but yet the properties are their pensions. So they might have 5 properties bringing in an income each month, but then if that income's not coming in, they're in trouble as well. And they're sort of retired older people that have worked all of their life. They've worked to build their pension pot as in property, because a lot of pensions weren't worth much. And now that rent's not coming in and they're heavily reliant on that. So they're in a bit of a pickle. So it's kind of like, okay. And now what I'm finding now, as we're sitting here today on the 17th of June, is an influx of all the old maintenance, because it went quiet on the maintenance side.
Yeah.
Not a lot of tenants.
You just couldn't get in.
No, and I had a tenant this morning text me saying, David, what's going on with all the repairs? I said, well, like the court system, you're in a queue for priority. So he's like, oh, I'm really fed up. I want this done, I want that done. It will get done. But what you've got to remember is every letting agent is running ragged, really busy now, because we've got, you know, 7 tenants to each property now. It's insane. You've got contractors who've got a backlog of work and they need to make up the lost time. And it's again, join the queue system. So it's really had a ripple effect.
No, I've seen that. I mean, I know you deal with a slightly different marketplace to me at Unique Property Company, but we've still got tenants who are actively very aware about certain things that need doing, or, you know, rent arrears. We just, you know, even at the high level, rent arrears is still a factor. 4 sharers, you know, with $1,000 a week property in Hoxton or something like that. Beautiful warehouse that we have, but just, you know, you have to, sometimes people furlough and don't have the money. So one tenant's paying more, and look, you try and do what you do, because we're nice letting agents. There's a lot that are. Yeah, we're here to help. That's the idea. So after David's little impassioned plea, how do you guys go, Gabriella, Louise? What are you advising landlords to do when they first got the phone?
Sell.
Yeah. I mean, yeah, as you guys said, it's kind of always best to consider whether there's any alternative. Sorry if you can hear my dog. It's always best to consider whether there's any alternative option than issuing proceedings. But this does largely depend upon those individual circumstances. And while the government is advising landlords and tenants to work together to reach some form of agreement, it's not always possible, not in every circumstance. So ultimately, if landlords are kind of suffering financially and, you know, there is no alternative option, then they're not precluded from starting those possession proceedings by service of a notice. No. So yeah, it really depends upon the circumstances as to what our advice would be. But as you guys are kind of urging as well, to try and reach an agreement as opposed to starting that lengthy process.
Yeah. Would you say to them it's better to avoid, like we're saying, or is that something obviously it's not in your interest primarily as a business, but I don't know, sometimes it, you know, being friendly actually could work out in the long term for you. I don't know if that's something you're doing. Yeah,
I mean, if possible, yes. Best is to try and avoid issuing proceedings. As we've discussed, it's not going to be a quick fix. Although there are accelerated options available, they're unfortunately not as quick as landlords may hope, and they're definitely not going to get any quicker now. So yeah, it's always best to try and negotiate a deal if possible.
Yeah, you got to deal with what you've got, exactly.
Yeah.
I think, well, from our angle, we're starting to see some positive changes. Tenants working with landlords. We've had one property where it's just a single guy in a studio, fell on hard times, and the landlords just said 3 months, absolutely fine, 3 months. and pay it back when you can. If not, we'll work out an agreement. And he's just signed a 2-year renewal. So that's a nice story out of it, isn't it?
That's really nice, isn't it? And it is. It's a lot. I mean, because the government have said, you know, you should work with your landlord, work with your tenants, and it's exactly what we're doing. Because Danny and I do work in a very similar way, where we do actually give a monkeys about our clients, and surprise, surprise, and the first thing to do is help. So we've had that journey where we've met the tenant, we've done the viewing, we've followed it through, we've got them into their property, we've welcomed them to their new home, and then all of a sudden we're not going to be horrible and just say, no, this is not acceptable, you've got to pay. Just talk to us. And first thing we all did was, when they announced this, right, the first thing I did, I went onto my software, I templated an email, and I sent it to all of my tenants. Look, just to let you know, this is the current situation. We're not going down to reduced hours, we're still there, but do bear in mind that it's going to be busy. Talk to us. If you're having trouble, talk to us. And that's the first thing I did to all my tenants, and a lot of them appreciated that. I did it to my landlords to say, look, we're not shutting up shop, we're still working from home, we're still here for you. And it's a case of, you know, that is the first thing you should do. Just try and help everyone and help that situation, because no one likes going to court. No one, well, you guys might, you know, no one likes filling out court paperwork. It's tedious, you know, and it's just literally, but you guys are the same, you know, if that is your job, but if you can avoid having that, because the thing is, whilst I love my job, I don't want to do too much, because then my service will be watered down. So I've had a few clients approach me and I've had to say, I'm sorry, I can't take that right now, maybe at a later date, just because I don't want to give them a watered down service. I digress anyway, sorry, someone else.
No, it's fine. You're entitled to have a home life when you're working from home. So, yeah, I mean, in summary, we've kind of come to the conclusion that you can, and if you need to, do it, but you join the queue, do both, a mix of, you know, all the stuff you can do. It's better to instigate a solicitor than try and do it yourself, because
absolutely,
by and large, it doesn't work. But then it's costly. I mean, what's the average cost of issuing proceedings at the moment if you're a standard client? What's your standard fee?
So if you're doing we do offer a complete package right the way from a notice all the way up to a possession order, and that's 800 plus VAT. That's just in respect of our fees. You've obviously got the court fee. I mean, the court fee alone is 355, so that's not an insignificant sum. And then if you have to go the whole hog and get a bailiff out, you're looking at more court fee for the bailiff, and our fees to help with getting the warrant of possession in. So probably all in all, you're looking at at least 1,000 to get back possession if you're having to do the whole process.
Yeah, but if you've got a troublesome tenant, or that things go south and you can't do anything about it, it's the only way.
Well, there's so many DIY landlords out there that, you know, I think the girls will probably agree. Judges don't like landlords or even agents doing Section 8 notices now. They want a solicitor to do it, you know, and that is the thing. And it's, you'll have a landlord go, oh yes, well, I downloaded a template from the such and such society and I've tinkered with it myself. I mean, I had one, she, believe it or not, she was a letting agent. She came to me and she said, I filled it out, and she was going for 2 months rent arrears, so Section 8, Ground 8, 10 and 11, and she didn't put Section 8 Ground 8 in, she just put 10, 11, 12 and another one, and all discretionary grounds. I said, well, as soon as that goes to court, that's been thrown out. She went, oh, I submitted that a couple of months ago. I was like, well, you get a solicitor. Oh, but they're expensive. Well, do you want possession, or do you want this to go on forever? And that arrears to then go, so like, you know, Louise just mentioned, you look at 1,000, probably 1,500 quid. Then you've got the rent arrears on top of that as well. So it just mounts up. So I think just nip it in the bud early.
Yeah. Well, that's the message we're getting out of this. And have you seen any positive stories, guys, out of lockdown? Because I know that we've got a few, but I'm just wondering if there's any that have just made your clients' lives easier. Is there anything?
Yeah, I mean, I've had a couple that were already in court proceedings, and they, unfortunately, there was one that they had a hearing just as lockdown. I think it was that Monday that we were all put into lockdown. They were meant to have a hearing, but it was pulled on the Friday. And the client emailed me a couple of weeks ago to say that the tenant had abandoned the property and had gone. So that client was really happy, obviously, that got back. No, Absolutely. I mean, that is quite uncommon. You'll have a lot of tenants that do stay because by leaving, if they're looking for assistance from the local authority, unfortunately, they'll make themselves voluntary homeless. So you do get some tenants that do stay put because they are told to from the council. But yeah, that one went, and also another tenant left as well, and that was a local authority one. They were involved, and they managed to get them rehomed. So it does happen, but it's not common, unfortunately. So yeah, a lot, 9 times out of 10, unfortunately, landlords do have to go the whole way.
Well, there's not much. At least there's some positive stories, and we'll get there in the end, I suppose.
Absolutely.
Well, thank you all. You can get all the information for BTMK, Louise and Gabriella at the bottom in the comments. And yeah, but thank you guys, and hope we'll do a video in a couple of months, see how things are going on.
Thanks, Danny.
Yeah, thank you very much.
Thank you.
Cheers.
Thanks,
Bye.
guys. Bye.